On behalf of the entire New College community, our lectures trustees, our board and staff, collegians residing here and across the road at New College Postgraduate Village, and our 7,000 alumni, may I begin by warmly welcoming everyone who is here with us this evening. For those returning from last night, welcome back. For those joining us for the first time, welcome. In spite of the minor challenges of teleconferencing, last night we shared a thought-provoking time discussing trends in family life over the last 50 years or more. We love to talk about the evidence base, and Professor Parkinson was extremely careful to support his views with a significant breadth of studies internationally. I'm not sure how others felt after last night's lecture, but I actually felt a little emotionally overwhelmed by the lecture and the subject's subsequent discussion. Here at New College and at New College Postgraduate Village, we aim to apply the highest levels of pastoral care to those who are able to join our communities here at the University of New South Wales. And during the course of that, we do find people disclosing major family trauma to the deans of our colleges. The deans and I are continually considering how best to help people through the difficulties that they confront as they come to university. Professor Parkinson last night exposed some of the underlying social forcings and the prospect that what we will see at university level will continue to develop over the coming decade at least. However, before we begin our time together this evening, I wish to make two acknowledgements. The first is to those who've lost close family members to their families during this very difficult COVID year, and there are several people within our college communities that have had that experience. The second is to the medical people, traditional custodians of this land. We pay our respects to their elders, both past and present, and extend that respect to other Aboriginal and Torres Strait Islanders who are present here with us today. As I said last night, we paused during this difficult year to return to important social and legal issues. Physically able to be present here at New College this evening, and there are others joining us via Facebook Livestream, as well as other people who will hear a summary of this material presented on ABC Australia. I will note that a full transcript of Professor Parkinson's first lecture is already available on the ABC Religion and Ethics website. A recording of the Facebook livestream is available on the New College Community's website from the lectures page. Again, I acknowledge my fellow New College lecture trustees, the Right Reverend Dr. Michael Stead, Bishop of South Sydney, and Professor David Cohen, President of the Academic Board, who's not able to be here but is watching us at home on live stream. I wish also to acknowledge distinguished guests who braved the COVID hazards to be physically present here with us this evening. Representatives of present and former New College boards, Mrs. Janet Simpson, the New College Board Chair, Mrs. Elizabeth and Mr. Tim George, and Ms. Jane Pangakula. We have distinguished academic visitors with us, Emeritus Professor David Black and Mrs. Ander Black, Emeritus Professor Michael Lawrence and Mrs. Sarah Lawrence, and Professor Michelle Riondo from Australian Catholic University is also with us. And other distinguished guests include Reverend Dan Anderson from Trinity Chapel and Robert Menzies College at the University of Macquarie. As I said last night, we received apologies from the Premier of New South Wales, the Anglican Archbishop of Sydney, and the President of the Australian Human Rights Commission. As I said last night, we love questions at the New College lectures. Our attendees peppered Professor Parkinson with questions last night at our lecture. For those who are present here, please feel free to write your questions on the paper slip that we've provided and hold them up, and an usher will collect them. For those here with their electronic device, or those watching via live stream, please go to the Slido website and enter the hashtag NCL2020. There are instructions over here on my right, your left, and for those watching on live stream, they are also circulated in an email prior to the lectures. Housekeeping matters, fire alarms, please go out to my left, your right, and go straight out of the building. And if bathrooms are what you need, go out on my right, your left. Let me just begin this evening by praying for us. Dear Heavenly Father, as we meet here again this evening, we thank you for the freedom we have in this country to discuss matters of belief and faith without fear, We pray now for your blessing upon our lecturer this evening, that you would grant to him clarity of thought and expression. Please, through our time together, grant us knowledge of you and a better understanding of you and your ways in this world. In the name of Jesus we pray. Amen. Please join me in inviting Professor Patrick Parkinson, AM, to address us.
Thank you, Master. Distinguished guests, ladies and gentlemen. As I said last night, I really am sorry I cannot be with you in person, but these are the circumstances of our day. And as I said again, also last night, I want to make clear that the views I expressed tonight are purely personal ones. I say that because I am an office holder at the University of Queensland. I am the Dean of Law, and I do not speak on behalf of the law school or university in anything that I say tonight. I know that's obvious, but it's probably worth saying particularly tonight because I've chosen as part of the discussion of material tonight to criticise some of the policies, or one of the policies at least, of my own university. Now, you may have heard that University of Queensland has had, I've found, a very, very strong commitment at that university to freedom of speech and to academic freedom. I've had very strong personal support from the senior leadership of the university when I have engaged in controversial issues in the public square. And I did advise the Executive Dean and the Provost that I was going to be commenting adversely on a particular University of Queensland policy tonight. Were they thrilled? I'm not sure they were, but they didn't and wouldn't have dreamt of saying so, because they back completely my freedom to do so, my freedom in the name of proper scrutiny and free debate to use my legal expertise to comment on matters of public relevance. And that's as it should be. I'm sure at the University of New South Wales there is an equally strong commitment to freedom of speech and academic freedom. Without that tradition of free and open debate and research which follows the evidence wherever it leads, however inconvenient the truth that may be discovered, we might as well close the universities down. Which is perhaps a good segue to tonight's topic, because we're going to be talking about issues of freedom of speech and the pursuit of truth. And these are not easy topics, and some of what I have to say tonight will no doubt be controversial. So be it. It's better that we air controversy than that we bury or suppress it. Well, last night's topic, as the Master has said, was about families, family stability, and I focused in particular on the impact of family instability on the mental health of children and young people who will be the next generation of parents. I talked also about the loneliness, which is going to be an increasing feature of the life of our society as people find it harder and harder to find and to maintain stable partnerships in their personal lives. And all of this has considerable impacts for the future of the church, and that's something I want to come back to tomorrow night. But before we get there, we need to address another issue, which is the issue of religious freedom, a challenge, in my view, to the church, a challenge that we need to see off in order to be the church that God wants us to be. So that's where we're going tonight, and I hope tomorrow I can bring those themes together, and you can see the relevance of it all for family and for faith in a multicultural society. But let's begin by making clear what is not threatened. There is no likelihood at any time in my lifetime, at any time in your lifetimes, that freedom of worship will be restricted in Australia. I cannot see it happening. And there's a very good reason why I can't see it happening. That is because no one much cares whether I go to church on Sundays or play video games on Sunday mornings. It doesn't matter to anybody else. I have the freedom to do what I want on Sunday mornings, and I don't expect that to change because no one else is affected by my exercise of the right of freedom of worship. As Professor Stanley Fish once put it, tolerance is exercised in an inverse proportion to there being anything at stake. Tolerance is exercised in an inverse proportion to there being anything at stake. That may be a bit of a theme, a leitmotif for us tonight. So what is threatened is not what I do on Sundays, but what I do on Mondays and through the working week. Increasingly, in my experience, and I'm sure in many of yours as well, there's a mood of hostility towards people of faith to the extent that they express their beliefs in the public square. Nobody minds terribly much even what views I hold in private. But it's when I go into the public square that can generate significant hostility. And this is part of a much broader erosion of freedom in our society, which may not be specifically targeted at religion. This is an important point I want to emphasize later, but which disproportionately affects the expression of religious belief. Well, to unpack this, I need to talk about freedom of religion in the context of three other freedoms. I see there being four freedoms which are indivisible. They all hold together. The other ones are freedom of speech, freedom of association, and freedom of conscience. Without the other three, freedom of religion becomes nothing more than freedom of individual belief and freedom for private worship. Take freedom of association to start with. Freedom of association allows us to gather publicly, to worship together, to be a Christian community, or as the case may be, to be a Jewish community, or a Muslim community, or a Mormon community. Being a religious community involves necessarily having boundaries. We need to decide who is permitted to belong to our group and who is excluded from our group. That's pretty rare to find a religious community which does not invite people to attend. Almost all religious groups are welcoming of people who are searching, people who might want to explore the possibilities of that faith. But a lot of religious groups are much more cautious about becoming a member of the organization, the church, or other community, as the case may be. And they will have rules for that membership. My wife and I go to a Baptist church. We have done for quite a long time now. And in traditional Baptist churches, as you will know, the criterion for membership is that you have been baptized as an adult, or at least as an adolescent believer. That's the criteria for membership within a traditional Baptist church. In many evangelical student societies, the criteria for membership, or at least for standing for an office, is that you adhere to a set of beliefs, a creed, a statement of faith that the society holds. So these are criteria for membership or for holding office within the society or the group. But just as there are conditions for being a member, there may be grounds also for exclusion. For example, a faith group may exclude a couple from the fellowship or deny them communion because they're living together outside of marriage. You may think such rules are entirely valid. But some of you in the audience tonight, and some of you listening on live stream or watching on video subsequently, may find it abhorrent that a religious group would exclude a couple just because they're living together outside of marriage. You may say that the religious group should not discriminate against any couple based upon their sexual conduct in private. And of course, you're welcome to your view. But you may go even further. You may say not only that it's wrong for the religious group to discriminate, but they should not be allowed to discriminate. That's a much stronger claim, that they should not be allowed to discriminate against a couple based upon their sexual conduct in private. And if you do hold that view, what you are questioning is not freedom of religion so much as freedom of association. You are questioning the right of that group to maintain the boundaries of inclusion and exclusion in accordance with their beliefs. That's about freedom of association, and it applies to any group. It applies to groups based on religion, ethnicity, political conviction, concern for a particular cause like an environmental group, or even just some activities such as bushwalking. Groups, in order to have freedom of association, must have the right to determine who is in and the basis on which somebody might be excluded. That's freedom of association. And you can see that it only really becomes an issue when other interests are at stake, and in particular, when other rights are at stake. Now, we could say the same thing about freedom of speech. Freedom of speech is essential to freedom of religion. It is intimately connected to freedom of religion. Why? Because the freedom to speak or write about your beliefs is just fundamental to faith. The right to preach a sermon, the right to post a blog on the internet, or commentary on your Facebook page, the right to engage in conversation around the water cooler about matters of faith. All of these are aspects of freedom of speech. Without freedom of speech, there's no freedom of religion. There's just freedom of worship. Well, the last of the four freedoms is freedom of conscience. I need hardly spell that out, because so often when issues of conscientious objection come up, they are based upon religious belief, not always, but very, very often. Concerns about life, an objection to military force, an opposition to abortion or to euthanasia. These very often, if not typically, come from a religious conviction. And like all other freedoms, freedom of conscience does not become much of an issue unless someone else's rights or interests are affected. Think about pacifism, for example. That's a well understood, well accepted basis for conscientious objection. Those who object to going to war have long been exempted in Australia and other Western societies from the duty to join the armed forces when conscription is operative. But nobody's really affected by that. There's very few who've in the past claimed that conscientious objection, and it only minusculely affects any other person, slightly reduces the pool of people who might be eligible for military service, but only marginally. So that doesn't really affect other people. Objections to performing an abortion or assisting in an abortion is really not an issue for anybody else, because if you have that objection, you're not going to apply for a job in an abortion clinic. You're not going to want to work in a part of a hospital where abortions are performed. You simply don't apply for the job if that's something you would object to. And when other issues of conscience come up, very often by sensible back office rostering, you can avoid the problem as an employer, as a manager. You can make sure that the person is not put in a situation of particular duty which they feel uncomfortable with. And nobody else would know, probably, except the manager and that person. It can be handled quietly in that way. But sometimes freedom of conscience conflicts, again, with other rights. And then we see how much weight our society places on freedom of conscience. And I'd have to say, not much. So the issues really about freedoms are when they clash with rights, when they clash with other people's rights, in particular, or people's claims of right, which may or may not be the same thing. And the problems we're seeing with religious freedom now have a number of origins that we can talk about. The first problem is the pathetic weakness of freedoms. Freedoms, as a matter of law at least, are very weak, pathetically weak, in fact. Now, you may say that religious freedom is a cornerstone of the Western legal tradition, as is freedom of speech and freedom of association. That is about as meaningful as saying that being embarrassed about sex is essential to what it means to be English. The English are very embarrassed about sex. Sometimes I wonder how we manage to reproduce. We get so embarrassed about it. But that's just a characteristic of what it means to be English. It's not as if it were in the DNA of an English person. It's a characteristic. And freedom of religion, freedom of speech, and freedom of association may be characteristics of the Western legal tradition, but they're not in our DNA. They're not fundamental values. Indeed, historically, religious freedom is quite a recent phenomenon. Ask the Huguenots, ask the Anabaptists. At various stages in various countries, ask Catholics and Jews how much religious freedom they experienced. And from their graves, they will witness that our commitment to religious freedom does not have very ancient roots. Beyond this, freedom is pathetically weak because it's not supported or buttressed by law. To claim I have a freedom to do something provides no defence to a legal action except to the extent that I can assert successfully that there is no law against the impugned conduct. That is, to claim I have a freedom gives me no entitlement, no power to lodge a complaint or to bring a legal action. Indeed, you can't really talk about a legal freedom. All that you can say is that if I'm free to do something, there is no law which prevents me from doing the thing that I want to do or saying the things I want to say. And no one has a legal right to take action against me for those things that I do or say. That's what freedom is. Freedom, in other words, in law, is simply the absence of restriction. What that means is that freedoms may be little more than temporary vacuums that have not yet been filled by legal regulation or prohibition. They're like crown land, land which is open to all, yes, but only so long as the government has not sold it into private ownership, or leased it to a developer, or given exclusive grazing rights to a farmer. Freedoms last only as long as governments do not interfere with them, and they exist only to the extent that governments choose to leave that freedom in place. Freedoms are pathetically weak on legal terms, and in the absence of a constitutionally entrenched Bill of Rights, they are as powerful a defence as a wall of straw bales against a bulldozer. Well, true it is that courts must interpret statutes with reference to what's called the principle of legality. That principle requires that statutes be interpreted with the aid of a presumption that Parliament does not intend to interfere with common law rights and freedoms, except by clear and unequivocal language. But if Parliament is clear about its intent, it can do whatever it likes. Now, you may say that this is an argument for a constitutionally entrenched Bill of Rights. And if my good friend George Williams, your Deputy Vice-Chancellor, formerly Dean of the Law School, were here tonight, he would say yes. The answer is a constitutionally entrenched Bill of Rights. I know that because George has been saying it again and again and again for many years, and nobody seems to be quite listening. One of the reasons is that in Australia, it's extraordinarily difficult, actually, to get amendments to the Constitution passed. There have been a lot of referenda, but very few have succeeded. Australians are quite cautious about any amendment to the Constitution. So if we were to have a Bill of Rights in Australia, it would have to be something less than a constitutionally entrenched Bill of Rights, something much weaker. It becomes little more than an aid to statutory interpretation in reality, which is what the principle of legality already gives us. Look, I will concede that in other jurisdictions, Bills of Rights, Charters of Rights, Human Rights Acts, whatever you may call them, do sometimes help. There have been some good decisions of the United States Supreme Court in recent years. There have been some good decisions of the Supreme Court of the United Kingdom. However, I have to say these cases are comparatively few. If one takes a look at the run of cases which have been fought in England under the Human Rights Act, the Charter of Rights in Canada, other jurisdictions, the overwhelming impression that I get from those cases is that courts are breathtakingly dismissive of the rights of freedom of religion and conscience whenever other interests, beliefs, and values are an issue. They will protect religious freedom when no other significant interests are involved, but not otherwise so often. Remember, tolerance is exercised in an inverse proportion to there being anything at stake. Well, human rights lawyers will tell you again and again that all rights and freedoms have an equal status. All rights and freedoms are equal. None are more fundamental nor important than others. If rights conflict, they will tell you, the decision maker must balance the competing rights. That language of balancing disguises huge value judgments. What so often happens is that the result of that balancing exercise is to subjugate religious freedom to other rights and interests. All animals, as George Orwell told us, are equal. But some animals are more equal than others. And so it is, it seems, with rights and freedoms. When the balancing is done, so often, freedom of religion seems to lose out to other interests. So freedoms are weak. They exist only to the extent that legislatures have not intruded upon them by regulation, even where freedom of religion and conscience is protected in law, secular courts imbued with the spirit of the age typically do so little to protect them. Well, that's the first reason. Freedoms are pathetically weak. The second reason why freedom of religion is in trouble, but also other freedoms, is because all of us have megaphones now. These days, when someone says something controversial on social media, as you know, it can create a Twitter storm. Hundreds, even thousands, can express their views, not only to the person who expressed the original view, but to all the others who are online. It quickly becomes a virtual lynch mob. And it's easy to mistake that for public opinion. And I get the impression that a great many journalists do. But putting it into perspective for a moment, there may just be a few hundred who are involved in this parlor, even a few thousand. In a population of 25 million people in Australia, that's not many, but it can be mistaken for a majority view, and journalists can present it as a majority view. And people who fear the lynch mob on social media can be intimidated into silence. They go along with the groupthink. They keep silent about their views, and if they transgress, not infrequently they will issue a grovelling apology. All of us have megaphones now. People can give the impression of representing large numbers of people simply by claiming to represent them. All you need is a website or a Facebook page, maybe some letterhead, and a lot of chutzpah. You can then speak to journalists or make submissions to government claiming to represent a much larger group than you do. It may be just two men and a dog. It may just be you and your dog. It may just be you and your pet clownfish. But you can claim by the title of your group to represent a much larger constituency and to put in submissions to Parliament or to make posts on social media seeming to represent a much larger group. And that can give tiny groups an outsized significance. What all this means is that in a time when everyone can speak, when all of us have megaphones now, we've never been less free to speak our minds, to express our opinions on anything which is controversial in the minds of the guardians of the public square. We are increasingly intimidated as a society by angry and extreme minorities, but aided and abetted by enough people in the universities and in the mainstream media to give the impression that these are majority opinions. As a consequence, all freedom of speech is now under threat. Now, it's important not to interpret this as a particularly anti-religious phenomenon. Clearly, it's not. It's not even an anti-conservative phenomenon. It's not even just an attack on conservative views. Yes, sometimes it will be, but it's much more than that. Some of the most strident denunciations we're seeing today are by progressives attacking others who would describe themselves as left of centre or even left-wing, certainly progressive themselves, in particular traditional feminists. Try saying on Twitter that only women menstruate, or that what it means to be male or female is defined by the reproductive functions of our genitalia, and all hell will break loose, as J.K. Rowling has found out recently. There are all sorts of views which, in the eyes of some, are so disturbing that they must be shouted down. But disproportionately, this seems to impact upon speech expressing religious views, views which used to be mainstream. And it's precisely because they used to be mainstream that they are the most quickly and emphatically condemned. Religious views, together with views that are more likely to be held by traditionalists, tend to feature prominently on a list of hateful ideas. Why such fanaticism? It's difficult for me not to see this as a quasi-religious movement. Having a cause, a struggle, gives meaning and purpose for those whose lives are otherwise without meaning or purpose. It also provides a ready packaged set of beliefs and gives a sense of belonging with others who share those beliefs. There can be a sense of power in the parlor, much as rioters feel power amidst the destructive pandemonium occurring all around them. There is, oddly enough, pleasure in self-righteous rage. Well, the third problem is one of definition inflation. Another reason why religious freedom is under threat. There's a certain section of the university-educated community, and particularly academics, I would say, who insist on inflating the meaning of words of disapproval. This is a deliberate strategy to stretch beyond all reasonable recognition, sometimes, words that have emotive power. We all condemn personal violence, and as we should. We condemn abuse. And so what happens is that an ever-increasing array of things that people disapprove of are described as violent or abusive. Words, we are told, are a form of violence. Silence is violence. Recently, the Australian Feminist Law Journal published an article in which the author asserted that ascribing sex to a baby on a birth certificate is, quote, intrinsically violent. I never thought I'd see the day when a humble birth certificate would be bundled into the back of a police car and charged with an assault. That seems to be the world in which we now live. Words like violence have been expanded beyond all reasonable meaning. But it's not just words like that, it's words like racist, transphobic, are all given expanded meanings in the new lexicon. You will know other words, white supremacists, Nazis. The meanings of these are now highly unstable. They simply refer to views of which the person disapproves. Hate speech is another of these elastic terms. It can be given an extraordinarily broad meaning. And this becomes important because hate speech can get you into trouble before an anti-discrimination body, if the definition is that broad. Well, the next reason why religious freedom is under threat is connected to the last. We've so expanded our anti-discrimination laws and our ideas about discrimination that complaints processes established to assist victims of discrimination and vilification have been weaponized in support of particular causes. One way that this has happened is that people are now bringing complaints against other people, even though they're not personally directly affected by adverse conduct. This is not what anti-discrimination laws were ever meant to do. Complaints under anti-discrimination laws used to be made only by people who were in some way directly affected. Let me give you an example. Take sex discrimination. An employer might discriminate against a woman on the basis of her sex by overlooking her for promotion, out of concern perhaps that she might fall pregnant, notwithstanding that she might be entirely suitable for promotion or in an appointment context the best person for the job. Now, the law also prohibits indirect discrimination. This is where, for example, a policy in the workplace indirectly discriminates against women compared to men, having a much greater proportionate impact upon women than men. So you have direct discrimination, somebody turned down for a job or for a promotion because of their sex. And you have indirect discrimination where a policy in a workplace has an indirect impact disproportionately affecting women. But whichever version we look at, the circle of those who are affected is still limited. The potential complainants are only those affected in that particular workplace, the individual, or in the case of indirect discrimination, all the women who might be affected by that particular policy in that particular workplace. It's still a relatively limited circle of complainants. But what's happened is that we have so expanded the notion of harm that if someone expresses a view that someone else objects to on a variety of different grounds which are contained in anti-discrimination laws, then that alone can be the basis of vilification or discrimination. The complaint is brought simply because of the views that have been expressed with which somebody else disagrees. The shining example of this is Section 17 of the Anti-Discrimination Act of 1998 in Tasmania. It makes it unlawful for a person to engage in any conduct which offends, humiliates, intimidates, insults, or ridicules another person on the basis of various protected attributes in the Act. These include race, age, sexual orientation, lawful sexual activity, gender, gender identity, intersex, marital status, relationship status, pregnancy, breastfeeding, parental status or family responsibilities. You can see it's a long list. As long as the person reasonably interprets that as offensive, that is sufficient. Well, this section was used, as you may know, to bring a complaint against Archbishop Porteous, the Catholic Archbishop of Hobart. He was summoned before a Tasmanian anti-discrimination body for distributing a booklet put out by the Australian Catholic Bishops' Conference defending its traditional view of marriage during the same-sex marriage debate. The Australian Catholic Bishops' Conference was required to answer this complaint as well. The basis was only that the complainant had been offended by this publication, which was distributed nationwide and which expressed a point of view on a matter of national public debate in a very courteous and respectful way, as one might expect of the Australian Catholic Bishops' Conference. Now, that case is well known. Again and again, though, when I raise that issue, I've heard it dismissed by people as a once-off. Some of you may have heard already my interview with Andrew West, who I like very much, the ABC religion and ethics journalist. We've had many good conversations over the years. And when we recorded the interview, which played, I think, first yesterday, Andrew said, but come off it. The complaint didn't go anywhere. It was dismissed. It was withdrawn, in fact. And that's what I often hear. There was no harm done. Well, yes, that's true. The complaint was eventually dropped. But what is remarkable and troubling about the case is not that the complaint was made. Anybody has an entitlement to complain. The real issue was that it was accepted by the relevant Anti-Discrimination Commissioner in Tasmania, who saw it as a potentially valid complaint under the legislation, potentially unlawful conduct. Other complaints have been made against clergy on the same basis under that section. Well, recent events demonstrate this is not just a once-off. About 3 weeks ago, on September the 3rd, Senator Claire Chandler, a Tasmanian senator in the federal parliament, received a letter from the same Anti-Discrimination Commissioner for Tasmania, same office, different person to the one holding office previously, I might say. And the Anti-Discrimination Commissioner summoned her to attend a mediation, a conciliation over a newspaper article she had written concerning, ironically, freedom of speech, and an email that she had sent to a constituent. In each of these, she expressed the view that women's sports, changing rooms, and toilets were designed for those of the female sex and should remain that way. The Commissioner apparently has found that this view could be considered offensive, intimidating, insulting, ridiculing, or humiliating. She went also on to say that it is arguable that it is no longer necessary to have separate toilets based on sex. So not only did she accept the complaint, but she engaged in her own argument with the senator on that subject. And as Senator Chandler observed in an outstanding speech in Parliament later that day, the Anti-Discrimination Commissioner is welcome to hold a different view to her on the issue of whether women's sports, changing rooms and toilets should be reserved for those of the female sex. She can campaign against Senator Chandler in an election. She's free to do so. But what is troubling about the case is that the resources of an investigative body that can make a finding and refer a matter to a tribunal which can impose unlimited fines is being utilized in what could be interpreted as an attempt to intimidate the senator into silence on an issue that she and many constituents feel very strongly about. The complainant was not even a transgender person. Now, once that was discovered, the Commissioner dismissed part of the complaint, but she still insisted on continuing with another part of the complaint concerning an email where the senator expressed that same view. Well, Senator Chandler just today has written to the Commissioner and indicated that she will not be withdrawing, retracting, modifying, or apologising for her comments on women's sports and women's facilities. I wrote to the Commissioner last Friday, drawing to her attention the principle of legality, which, if it is properly understood in this context, could not possibly support the interpretation that the Commission appears to be placing on that legislation. We do not interpret statutes to interfere with fundamental rights and freedoms unless they are unequivocal in doing so. These issues are, of course, very controversial. It's only recently that in Tasmania and Victoria, laws have been passed allowing self-identifying trans people. Let me make a point about both Archbishop Porteous's case and Senator Chandler's. In each case, they were defending the existing position in Australian law. The Catholic bishops were defending the position of the Marriage Act at that time, that marriage was defined as between a man and a woman. This was before the Marriage Act was amended in 2017. So they were defending the law as it then stood, the law of the country. Senator Chandler is defending the existing position that there is no requirement for female sports competitions to admit participants who identify as female but remain anatomically male. The law is clear on this. Section 42 of the Sex Discrimination Act 1984 of the Commonwealth provides that it is lawful to exclude someone from participation in any competitive sporting activity in which the strength, stamina, or physique of competitors is relevant because their gender identity is different from their anatomical sex. So the law is clear on this, and Senator Chandler's been making waves about the issue of rugby, female rugby, saying that anatomically men who identify as female should not be allowed to participate in rugby because of women's rugby because of the risk of injury. And of course, she's absolutely right. She's absolutely right in law, not just in policy. Section 42 of the Sex Discrimination Act is clear on the subject. The law in New South Wales is even clearer on this. Nothing in the Anti-Discrimination Act 1977 in New South Wales renders unlawful the exclusion of a transgender person from participation in any sporting activity for members of the sex with which the transgender person identifies. So you see, it simply cannot be unlawful in Tasmania for a federal senator to express an opinion that the law of the Commonwealth of Australia should be maintained as it is, or that the law of New South Wales should be maintained as it is, nor to insist that female change rooms or toilets be managed on the basis of sex rather than gender identity. The problem with weaponizing of complaints processes is that the defendant is typically put to a lot of effort and expense in responding to such complaints, even if they are eventually discontinued. And this has a chilling effect on freedom of speech. It ought to be entirely uncontroversial that Catholic bishops should be allowed to explain Catholic doctrine without fearing legal repercussions. It ought to be entirely uncontroversial that a senator should express a view publicly on a matter of controversy, which opinions differ markedly. These are foundational freedoms in any democratic society. But the fact is that they have been questioned. Those rights have been questioned. Those freedoms have been put in issue, at least in Tasmania. So these are issues about the reach of anti-discrimination laws. But there are also issues around complaints processes in universities and corporations. Not infrequently, issues will arise from codes of conduct of various kinds. Take my own university, the University of Queensland, which I've chosen because it's likely to be typical of many other policies to be found in universities, government departments, and corporations. Now, generally, the university's policy documents, such as our code of conduct, are well drafted. They're appropriate for their purposes. They say what you would expect them to say. They say what you would want them to say. But sometimes they contain some very vague and expansive phrases which are capable of definition inflation. An example is the student misconduct policy. Grounds of complaint under that policy on the basis of what's called general misconduct include the following: behaving in a manner that prejudices the reputation of the university, harassing, vilifying, bullying, or abusing staff, students, or other members of the university's community. There's no vaguer word than bullying these days. What does it mean? Well, the third one, behaving inappropriately in a university activity. You can see the problem of definition inflation. You can see how broad this is. And why is this a problem? Well, because it's a basic legal standard that if the Parliament wants to prohibit something, citizens need a clear understanding of the conduct that is being prohibited so that they can avoid the very thing that would contravene the law. In order to obey the law, you have to know what the law requires. This is the reason why criminal offences ought to be precisely and carefully defined. disciplinary codes in universities and corporations ought to adhere to a similar standard. They ought to be similarly clear about what conduct could contravene a breach of the university's standards and lead to disciplinary consequences. Well, a further feature of the UQ policy, which I should say is now under review, and again, I thank the university for listening to my concerns and others about it. A further feature of the UQ policy is that anyone, even a member of the public, completely unaffected by the matter personally, can complain about any student with the consequence that the complaint must be investigated. In this way, university complaints procedures can be weaponized. As head of school, I recently had a complaint from a member of the public seeking to invoke the university's disciplinary processes against a colleague of mine for a view he expressed on national television. Not only did I receive this email, but the Vice-Chancellor and various other people as well. What was the issue? Well, the complainant simply disagreed with my colleague's point of view. With this particular colleague, that's a pretty common experience, I might say. Well, I just said, you can write a letter to the editor or contact the TV station if you have a different view. But what he wanted me to do was to initiate a disciplinary process on the basis of misconduct, simply because my colleague had expressed an entirely reasonable view with which this person disagreed. Another example is public knowledge that there was a complaint against one of our undergraduate students from an academic at La Trobe University specializing in anthropology, something to do with Tibetan studies, if I recall rightly. And this complaint was based on a statement that this undergraduate made on Twitter in early January this year. The academic thought that the tweet constituted cyber abuse, but not cyber abuse against him. It had nothing to do with him. It's against somebody at the University of Queensland, nothing to do with him at all. He was not remotely affected by it. But not only did he lodge a formal complaint to the university under our student misconduct policy, but he encouraged others to do so as well, providing them with a link to the UQ website where they could lodge a formal complaint. Well, as I say, the university's policies and procedures in this area are now being reviewed. I raise this issue only because I think this is a very common issue across a lot of codes of conduct in universities and in large corporations, maybe in other settings as well. Well, these are general threats to freedom. They're not specific to religious freedom. But many such complaints will be about expressions of religious conviction or religious viewpoints on moral issues. Well, the other reasons that religious freedom are under threat is because now more and more categories of discrimination are unlawful. The list used to be just a few: race, sex, age, disability, more recently sexual orientation. But some states in Australia keep adding to the list. So, for example, among the 20 different grounds on which someone can now sue for discrimination in Tasmania is, quote, lawful sexual activity. There's a similar provision in Victoria. So could a church be taken to court for discrimination if it were to discipline a youth worker for engaging in frequent casual sexual relationships? Such activity is lawful. Another prohibited ground of discrimination is relationship status, which is in addition to marital status. So what if the youth worker were living with someone in an intimate relationship outside of marriage? Discrimination against a youth worker on grounds of lawful sexual activity or relationship status could get a church into trouble in Tasmania. But for the church, it's a matter of discriminating between right and wrong. Now, the situation is similar in Victoria, but at least in Victoria, there are very broad-based exemptions which apply to religious organisations and activities. But in Tasmania, those exemptions are very much weak. And over the last few years, we've seen more and more campaign against exemptions. There's a strong hostility to exemptions from anti-discrimination laws for religious bodies, a sustained attack on the established ways of balancing anti-discrimination norms with religious freedom rights. Now, there are moderate positions on this, of course, and more extreme positions. But a commonly expressed view is that exemptions in anti-discrimination laws are wrong and should not be tolerated. No one has argued should be exempt from the operation of general laws. Many advocates would like the law in Australia as a whole to be as limited as it is in Tasmania. But religious freedom rests so much on these exemptions in relation to church activities. Now, an example of this opposition to exemptions is some of the work of the Australian Human Rights Commission. It's ebbed and flowed in its support of religious freedom over the years. In the 1990s, it was really quite supportive of religious freedom. For a brief window of time when Tim Wilson was Human Rights Commissioner, it was supportive of religious freedom also. It seems to have gone backwards once again in recent years. An example of the problem is in 2008, when the Commission made a submission to a parliamentary inquiry. It questioned the exemption provided by Section 37 of the Sex Discrimination Act for religious organisations and proposed a 3-year sunset clause on its continued operation, during which time further reform could be considered. It did so because it said the permanent exemption does not provide support for women of faith who are promoting gender equality within their religious body. Let me unpack this for you. What effectively they were saying is that they were advancing a policy position that suggested it should be unlawful for the Catholic Church to insist on a male priesthood. Or at least they wanted that reform to be considered, and therefore any permanent exemption to be removed and for it to last only for 3 more years. And they did this even though they recognised that Article 6 of the UN Declaration on the Elimination of All Forms of Intolerance and Discrimination based on Religion specifically provides the right to train, appoint, elect, or designate by succession appropriate leaders called for by the requirements and standards of any religion or belief. No trivial UN Declaration of Human Rights would stand in the way of the woke folk at the Human Rights Commission. Well, it's common for other human rights organisations to argue against exemptions as well. This is becoming an increasing problem because, as I said before, religious freedom rests so much on the exemptions that are in these anti-discrimination laws. All anti-discrimination laws have to balance different rights and freedoms. A women's gym is an example. How can a women's gym be tolerated in an age of sexual equality? Because of exemptions or a similar draft device. How can a club survive in which only men may become members? Because of an exemption. How can a political party insist that all its employees support the political worldview of that party? For the same reason, an exemption. You see, exemptions play a very important role in balancing rights, balancing claims of discrimination. And religious freedom rests upon those exemptions. The trouble is it's becoming an increasingly narrow ledge. Religious freedom cannot properly be protected by grudging exceptions to otherwise applicable laws and anti-discrimination statutes. What is needed in the context of faith-based organisations, such as religious schools, is a positive affirmation of the right of faith-based associations to govern themselves in accordance with their traditions, their values, and their precepts, and to choose or prefer staff who adhere to the beliefs or values of the organisation in terms of employment. That in turn requires that religious organisations be permitted to adopt and enforce codes of conduct that are consistent with those values. Such a positive affirmation of the right to freedom of religion is for the most part absent from Australian law. But you see how much it's connected with freedom of association, the right of religious organisations to organise themselves and their schools according to their precepts and values. The freedom to advertise for Christian staff and Christian schools beyond just the chaplain and the school principal. The freedom to advertise for Jewish staff in Jewish schools, Muslim staff in Muslim schools, and so on. These are all critical to freedom of association. And for religious schools, they are an important part of building communities of faith. Freedom of association, at least for groups which exist for a cultural or religious purpose, are essential to being a multicultural and multi-faith society. So too is freedom of speech on moral and social questions and freedom of conscience. Currently, the law has little or no protection for those freedoms beyond, as I say, some exemptions in anti-discrimination law. Well, the organisation which I chair, Freedom for Faith, is very active in seeking to address these problems. It's a legal think tank drawing upon the expertise of legal academics and other lawyers around the country. We seek to develop bipartisan support for reasonable and sensible reform in this area. We talk with both Labour and the Coalition on such matters. We would also talk to the Greens if they were open to dialogue with us. The way forward is to find solutions to problems that are respectful of all the interests involved, and which allow people to live and let live, accepting their differences. However, finding solutions is increasingly impeded by hostility to people of faith. This takes me to my last point, which is the problem of discrimination against people of faith. Intolerance towards faith is becoming an ever larger problem in Australia. This is a troubling development in a society that is so multicultural. It threatens the cohesion of our society. Anti-Semitism, which is one of the most vile, but also one of the most persistent tendencies of Western societies, is emerging afresh in our time. Peter Curti has written a very fine paper on this from the Centre of Independent Studies. Anti-Semitic incidents in Australia increased by 59% in 1 year in 2018. Our Islamic communities feel under threat from the fear and suspicion that members of those communities may be associated with terrorist activities. For Muslim friends of mine, it is a terrible problem. They really are afraid of the public around them, just as the public, or at least some members of the public, may be afraid of them. Christians too are experiencing increasing levels of discrimination against them because of their faith. And mostly until now, this has been covert, but it's becoming increasingly overt. This was particularly seen in the debate about same-sex marriage. Various large corporations became hostile workplaces for anyone who did not support the management's strong endorsement of the marriage equality movement. Now, that debate is over. It's done and dusted, as I said last night. But advocacy groups have a number of other policy agendas they are pursuing, particularly transgender ones. Queensland and the Australian Capital Territory have recently passed legislation that threatens people with jail terms for providing therapy to children and young people who are experiencing gender identity issues, the therapy being to help them become more comfortable in their natal sex. Both Queensland and ACT have sought to outlaw that. In the ACT, it is now unlawful for parents even to obtain therapy of that kind outside of the ACT. Now, there are some qualifications on that for psychologists, psychiatrists, other health professionals, but it's far from clear whether the established clinical practices of psychologists and psychiatrists are exempted from the prohibition in those laws. People who oppose particular policy agendas of that kind, as I have done, find themselves all too readily vilified as homophobic or transphobic. This is a very difficult atmosphere in which to have calm and reasoned policy debates about the public good. My point is that these issues will keep coming, creating issues of conscience for people of faith. Another example is the pressure from some quarters for people to declare their preferred pronouns at the bottom of email signature blocks and in other ways. Christians and others cannot in good conscience accept the unscientific belief systems that underlie some of these policies, will find themselves increasingly thrown to the lions in large corporations and other workplaces. For that reason, let me say it is disappointing that there is not at this stage bipartisan support, at least in principle, for a federal law prohibiting religious discrimination. Universities also need to consider what they are doing about intolerance towards people of faith. Christian students increasingly report to me how hostile they find some university classrooms. I've heard particular concerns about social work degrees, but it's doubtful that this problem is limited to just one study area. A canary in the coal mine in all of this is the lack of inclusiveness of many secular organisations' policies on diversity and inclusion. Not infrequently, various groups are mentioned, but there's no acknowledgement at all of religious belief. To the extent that there is any mention, it is to be found in references to culture. We're inclusive of culture. But it's not only ethnic minorities who hold religious beliefs. Well, these are dangerous developments for freedom. The combination of all the factors I have described represent significant issues for the future of our democratic society. There's an element in our society that really doesn't have much of a commitment to freedom of speech, or freedom of religion, or freedom of conscience. There's an element that really doesn't accept the trade-offs and compromises that are required for a healthy multicultural society. There's an element which really doesn't believe in free debate, is not prepared to argue about facts or to listen to other opinions. That element in our society may be small, but it's fanatically self-righteous and very well organized. These people represent a serious threat to the cohesion of our hitherto successful multicultural society. The influence of this element is greatly enhanced by the megaphone of social media, supported by those elements of the mainstream press and television, which treat the endless expressions of outrage on this or that as a newsworthy story. While this element may be small in terms of the overall population, it is not small in universities. I can assure you, as someone who's been in the university sector for over 35 years, that the situation now is really bad. The level of censorship, at least on certain issues, is extraordinary. On issues identified as social justice concerns, it is extremely difficult to get published in academic journals because editors and anonymous referees act as determined gatekeepers to exclude certain viewpoints. Sometimes it's the editors who simply won't send an article out for peer review at all. Sometimes it's the referees who create spurious justifications for rejecting an article outright, not even inviting it to be amended. Referee reports which don't even attempt to engage with the substance of the argument, but condemn it because of the viewpoint. And it's not just the exclusion of viewpoints, it's also the exclusion of evidence that I have personally experienced. Censorship is increasing in the academic community, at least on certain issues. The fanatically self-righteous are afraid of open debate, dismissive of facts which contradict the received wisdom, afraid of evidence that might represent an inconvenient truth. An intolerant cancel culture is taking hold, more so in Britain than in North America than here for now, but it's certainly happening here as well. And it will happen with increasing frequency. To repeat the words of Professor Stanley Fish, tolerance is exercised in an inverse proportion to there being anything at stake. What's important to emphasize this idea earlier, this is not per se an anti-religious movement or even an anti-conservative movement. Even those on the left of politics, people who perceive themselves to be liberal, progressive, can find themselves subject to lynch mobs and vilified on social media. All those who hold views of the world that are endorsed as correct by the prevailing groupthink can find themselves subjected to ostracism, social media pardons, or even campaigns for their dismissal. That's very difficult for people who want to be accepted, praised, or just supported in their careers. It's difficult to be hated. It's difficult to go against the tide. Christians are not hated because they believe in God or go to church. No one, as I say, cares what I do on Sundays. However, Christians are more likely than others to be subject to hatred because they tend to hold traditional views and ideas. And the greatest irony in all of this is that so many of those who advocate to restrict freedom of speech, freedom of religion, freedom of association, and freedom of conscience proclaim themselves to be the guardians of human rights and to support diversity and inclusion. So there's an urgent need for the mainstream to rescue the national conversation from the extremists, to protect long-valued and fundamental freedoms. How that is a great challenge. Starting point perhaps is to make a determined effort to give megaphones to mainstream voices, rather than giving so much oxygen to the extremists. Those mainstream politicians who believe in traditional freedoms must become much more assertive, less cowed by Twitter mobs, more confident in their fundamental values. Much of what is fundamental to a free and democratic society is at stake. We need to work towards a time when once again the national conversation is dominated by the same. However, it may be that some of these trends, at least, are now irreversible. And tomorrow in the final lecture, I'm going to explore what that is going to mean for the church, for living in a society that is increasingly hostile to Christian beliefs and values. I will also address what might be done in the political realm to better protect freedoms. I hope that you will join me there. Thank you.
Thank you, Professor Parkinson. We now turn to a time of questions. And just to reiterate, if you have a sheet of paper on your seat, you're free to write on that and write your question there, hold it up in the air, and someone will come around and collect the question. Alternatively, you can pick up your electronic device and go to the slido.com website and enter the hashtag #NCL2020. So, with not much more ado, I'm going to move on to the questions that we have before us already. The first question is, how likely do you think it is that we will see reforms that provide positive protection of religious freedoms in the near future?
I have to say that if our current crop of politicians continue on their present trajectory, it is very unlikely. The Ruddock inquiry was a failure. There was huge effort put into the Ruddock inquiry. There was something like 16,000 submissions, many of them very lengthy. Freedom for Faith presented a very substantial report, about 100 pages, with very specific and clear proposals and recommendations for reform. Many other organisations did the same. But the end result of the Ruddock report has been pretty much nothing. So I am concerned. I am concerned about the lack of willingness to engage with this issue, the lack of bipartisan support for fundamental rights and freedoms, the betrayal of the values that politicians claim to hold around anti-discrimination. If you hold those values but you're not prepared to enact laws which protect those things, then your words are empty. And that's where we stand at the moment, I'm afraid. I'm hopeful that we will see much more substantial change. I hope that the extraordinary and appalling example of the attack on Senator Chandler's freedom of speech as a member of federal parliament will galvanise the federal parliament into action. There are things the federal parliament can do, there are things it should do, but it will require more courage and commitment than we have thus far seen, and more reasonableness on the other side of politics to agree on sensible changes to the law. Of course, the government is completely caught up, as the state governments are, with the issue of the pandemic. I entirely understand that. But I do hope, as that crisis eases, that we will look at the fundamental values of our society. We will look at the things we've held so dear for so long. We will see the extent of the threats, and we will take firm and strong action to support freedom of speech, religion, conscience, and association in this country.
Thank you. How does defending religious freedom fit with a Christian's expectation of persecution? Should Christians care so much about defending religious freedom when they expect to be criticised for what they believe?
Thank you for the question. Christians can expect persecution. Christians are persecuted, sadly, in many countries of the world, and increasingly so in more and more countries, it seems. Many have lost their lives as a result of their faith. So yes, we can expect persecution. We can expect trouble in this life. But Jesus did not say that we are to be doormats. Jesus did not say that we are just to allow all this to happen without protest. Paul, if you think about Paul's example in the book of Acts, when he was maltreated, he said, I am a Roman citizen. He referred to his rights, very powerful rights that he had as a Roman citizen, which made those who had ill treated him very scared once they realized that they had broken the law. So Paul invoked the law, he invoked his rights, and we pay our taxes. We vote in a democratic society, we can organize, and we are not to be doormats. So no, I think we must seek to defend our freedoms and the freedoms of others with whom we may have many disagreements. Freedom of speech involves freedom to allow others to speak and to express views with which we may profoundly disagree. That's fundamental. So protecting freedoms is really about protecting the human rights of everybody, not just people of faith. When it comes to freedom of religion, the freedom not only of Christians, but the Jewish community, the Islamic community, the Hindus, and many other faith groups. Freedom of religion must apply in an equal measure to everybody.
Thank you. Can you give some more specific examples of religious freedoms being trumped by conflicting interests?
I think a very good example which comes to mind is the Trinity Western case in Canada. Trinity Western is a university. It's a private university in British Columbia. It has a teaching program. It has a few other faculties as well. And some years ago, it wanted to set up a law school. Now, it's a very conservative Christian university in this sense, because any student who wants to come to the university must sign what's called a community covenant. And that community covenant requires them to say that they will abide by a code of conduct, which is quite extensive. It's actually an admirable code of conduct, not gossiping about others, not speaking ill of others, lots of things which go to how we should behave with each other, how we can love our neighbours as ourselves. The vast bulk of that community covenant was entirely uncontroversial, but it did commit students while they were at the university not to have sex outside of marriage, and it defined marriage as between a man and a woman. Well, so appalling was this, that 3 law societies of provinces in Canada said that because Trinity Western University engaged in discrimination, it should not be allowed to run a law school. It wanted to run a law school. Engage in discrimination? No, all it required was people to sign up on a voluntary basis to a covenant for how they would live, how they would behave, a shared set of standards for the community as a whole. And as you can understand, if there was a same-sex attracted person or a couple there, they were free to do so as well. They were free to come to the university. What they were not free to do was to engage in sex before marriage between a man and a woman. So it was a restriction on their freedoms, but only to the extent that they were at university and only if they voluntarily signed up to that. And of course, if you had a problem with that, you wouldn't sign up to it. You go to one of the many other universities in Canada, many other law schools. Well, this went up to the Supreme Court of Canada, and the right of the provinces not to accredit this proposed law school for legal practice was upheld by the Supreme Court of Canada. And that was a decision made under the Canadian Charter of Rights and Freedoms. Now, another point of view on this is we can live and let live. There are far too many law schools in Australia. There probably are far too many in Canada as well, I don't know. If there's another law school, well, it will stand or fall on its own merits. Nobody has to apply, nobody has to go if they don't want to attend. Nobody has to. Nobody's forced to do so, you see. So that's a good example of where a very intolerant approach was taken, a decision not to allow a multi-faith, a multi-cultural society to have different views and opinions when it comes to that issue.
Thank you. I'm tempted to rephrase this question, but I'm going to ask it specifically as it's written here. Are you saying that anything less than a constitutional amendment is ultimately inadequate in law?
Yes. Well, yes, but constitutional bills of rights, as you see in the United States, do have powerful effects because they give to the Supreme Court of the United States the power to strike down laws as unconstitutional. Something which can happen in Australia as well, of course, but mostly only where it crosses the divide between federal responsibility and state responsibility. There are almost no expressions of rights in Australia, although there is Section 106 of the Constitution, which does concern religion in fact, but it's been narrowly interpreted. So, constitutional protections for rights and freedoms, yes, they are powerful. But of course, the flip side of that is you see in the United States the extraordinary politicization of the judiciary, particularly the Supreme Court, playing out once again with the death of Ruth Bader Ginsburg. So there's a real downside, a real cost to constitutional bills of rights. It's not going to happen in Australia. We did have a vote on this a few years ago. There were a number of rights which were put forward for protection in the Constitution that none of them got up. None of them were close to getting up, actually. So what are you left with? Well, you're left with laws, statutes, which proclaim various human rights and freedoms. You have them in Queensland, the ACT, and Victoria. But they're not much more than aids to interpretation of the statute because they don't bind Parliament. They have some effects, but they're not as powerful. And each of those three states have great get-out-of-jail-free clauses where they say, well, you could ignore human rights if there's a sufficient reason for doing so. That's a paraphrase, but that's essentially what they say. So they are pretty weak. But there is a way to protect freedoms in Australia through federal parliament, and that is that a federal law can override an inconsistent state law. And this was done in the 1990s, funny enough, concerning Tasmania. And it concerned the issue of homosexual conduct. At that stage, Tasmania was, I think, the only state left in Australia which still had on its criminal law statute book an offence of engaging in homosexual conduct. And quite rightly, the UN Human Rights Committee said that this was in breach of international human rights protections. And the federal government, being responsible for the protection of human rights in Australia, passed an act of parliament to override Tasmanian law to the extent of the inconsistency. And we could do the same in terms of freedoms. We could say that through the federal parliament, we protect freedom of speech, freedom of religion, freedom of association, freedom of conscience, maybe any other freedoms that are relevant in this context. And then to say, to the extent of inconsistency, a state law which is inconsistent with that federal law will be invalid or must be read down to be interpreted more restrictively so as not to interfere with the federally enacted freedom and our international human rights covenants. So there is a way. That was a long answer, I'm sorry, but it's a rather complex question in law.
Thank you. You outline a number of tools that have been weaponised to reduce freedom of religion. Do you have any ideas what could be next? For example, what do you think of the increase in the use of codes of conduct to control citizens? Is this the latest tool of activists?
Yes, I think it is. I think it is. Diversity inclusion statements, they may be quite well-meaning and innocent in themselves, but I'm seeing them being weaponized to say, well, if you don't hold a particular view, then you are breaching the organization's diversity and inclusion policy. So my concern is that diversity and inclusion policies include everybody who agrees with you, but excludes those who don't. And that can be translated into codes of conduct, and then into disciplinary action. And we've seen this in many parts of the world. We've seen it in universities. We've seen it in the employment context. Less so in Australia than in other countries, but it's a very serious problem. Let me, if I may, just give you one example. I know so many of the examples do come from the enormous controversy we have in our society around same-sex issues. But just as an example, there was a counsellor in Bristol, in England. He was working in a relationship counselling organisation, and he expressed the opinion, expressed the view to his supervisor that while he was happy to counsel same-sex couples, he had absolutely no problem with that. He didn't feel he could engage in sex therapy with same-sex couples, and he was training to engage in sex therapy as well as the relationship counselling that he had been doing. So he said, look, I just don't feel comfortable with this. And he was a Christian man, he was an elder in his church. And as a consequence of saying that he didn't feel comfortable about engaging in sex therapy with a same-sex couple, he was hauled for the organisation accused of gross misconduct, and he was fired. Now, that organisation would have quoted its diversity inclusion policy, but you know, that organisation became less inclusive the day that man walked out of the door. For a number of reasons. One, there was one less Christian who might give a lot of support to Christians coming to that relationship counselling organisation. The second is that he was a Caribbean English person. He was a black man, hailing from the West Indies. And so the organisation was ethnically less diverse when that man walked out of the door. It would have been so easy, wouldn't it, for that organisation just to say, look, we respect your difficulties. There's many other people who can provide that counselling. You don't have to. It would have been so easy to have done that. But that code of conduct was weaponised to dismiss a good and decent man who was probably an excellent counsellor, who had so much to offer the clients of that organisation, but who held the wrong point of view. I think we're going to see this more and more.
I'm rephrasing the next question slightly. Would you be able to comment on the philosophical underpinnings of this hostility to freedom of religion? The question that refers to cultural Marxism as a terminology, but perhaps you might like to comment more broadly.
Look, I'd rather defer to others who could explain it a lot better. There's been a book published just very recently called Cynical Theories by Helen Prose and James Lindsay, I think, are the authors. It is available. You can download it from Amazon or other such services as an e-book. I've started reading it. It's an excellent introduction to postmodernism and how postmodernism has been adapted to become the philosophical underpinning of this idea. But in broad terms, the idea that there is no truth, that language is power, and all these sorts of ideas then translate into there's no point in arguing over facts, there's no such thing as objective evidence. And so it's all about power, it's all about language, it's all about your point of view, and therefore you can shut other people down. There's no ground on which you can share commonly. You can debate with other people because there's no objective truth which you can argue about. This is very anti-intellectual, but it is the belief of a lot of intellectuals.
The next question is, it might be argued that freedom of religion rests more securely on a cultural ethos than the law. Is this the case, that once we're in a position of needing legal defences for these freedoms, we've already lost the battle? Perhaps you're going to talk about this tomorrow night, but do you have any thoughts on this, ideas on how to reshape culture?
I do. Thank you for the question again. As last night, these are excellent questions. I think that we need to reclaim the national conversation, but fundamentally, we have to decide whether we're going to be a secular society or a multicultural one. And I think that's the fundamental choice we have got. What I'm arguing for is the maintenance of a multicultural society which you can respect different views, different faiths, different ethnicities, different backgrounds and cultures, and live and let live harmoniously as a society. And those are values And they're values which have served Australia very well. And I think we need to reinforce those cultural values. The problem is that when you think about how societies are run, almost all the political conversation is limited to about 6% of the population, possibly much less than that, maybe 2%, I don't know. But the people who engage, who write opinion articles, who go on Twitter, who publish blogs, who express points of view, who talk about politics around the water cooler, they are a small minority. And of course, some of the most passionate, but some of the most extreme of those join political parties and engage in activism. So we have a situation where there are values which are widely shared in the Australian society, but it's a small minority who push through laws and cultural changes of practice which do not represent in any way a majority view. So what happens? Well, we may have a say in an election, but elections are fought on all sorts of things. They're fought on the economy, they're fought on all sorts of other things as well. So we really have to find a way, I think, to marginalise the extremes and to bring the mainstream to national conversation. That will take courage. It will mean standing up to these thugs, these intellectual thugs who try to silence freedom of debate. It won't be easy, but I agree with the questioner. We need very much a culture of freedom of speech, a culture of academic freedom, a culture which sees ours as a successful multicultural society and which seeks to protect that. A culture which stares the thugs down.
Well, as I promised, we've peppered our lecturer, so I'm only going to ask one more question before we close, and this is as follows. Codes of conduct are increasingly being used by Christian organisations to access exemptions under anti-discrimination law. Do you have any thoughts on this? How should Christian organisations seek to access these exemptions?
We are possibly leading into some of the topic for tomorrow night, but that's okay. I think there's a fundamental distinction, and one that I've drawn out in an article with Joel Harrison and the Monash University Law Review in 2014, between organisations which are in what I call the commons, commerce, education, government, and so on, where we all live together, work together, operate together in our society. And there have to be common values around that. There have to be anti-discrimination laws which prohibit discrimination on the grounds of race or age or sex or any of those things, or indeed sexual orientation. So these are general anti-discrimination laws which apply to the whole community and must, in the spheres of operation where we all live and work together as a society. But there are also a large number of groups which are not in that mainstream, in that commons. These are voluntary associations, they're religious groups, they're political groups, they are environmental groups, they could be all sorts of things, where people come together because of their shared values, because of the shared beliefs, because of their shared cause. And these groups need to be able to choose, as I said earlier, who should be a member, who should be excluded. And codes of conduct do that, and are maybe necessary in order to maintain the values and cohesion of the group. But that is because it is a defined and specific group which is coming together voluntarily. That's the big difference. So, yes, there will be churches who say if you live together outside of marriage or if you engage in casual sex, you can't continue to be the youth worker or the pastor. Churches which will expel a pastor because he commits adultery and so on. There are churches who maintain these standards, but that is because they are founded upon a shared set of values which underlie the work of the church, and that's different from the general community. So that is quite a long answer, but we will pick it up a bit further tomorrow. Codes of conduct in that context, whatever the group may be, are entirely valid and appropriate.
Thank you. I'd like to call on the Bishop of South Sydney, Right Reverend Dr. Michael Stead, to move a vote of thanks.
As one of the three trustees of the New College Lectures, it is my pleasure to offer this vote of thanks to Patrick for this wonderful lecture tonight. Patrick speaks to us with great authority and depth of insight on this particular topic. I've had the privilege of working with Patrick closely on these matters over a number of years in relation to the Ruddock inquiry and submissions in relation to the Religious Discrimination Bill. And can I say that every time I've engaged with Patrick, I've learnt so much, and tonight is no exception. There were a number of highlights for me from the lecture tonight, and I won't try and list them all, but there are a few in particular. Firstly, Patrick, I really appreciated the way that you teased out the inherent connections between freedom of association, freedom of speech, freedom of conscience, and freedom of religion. And indeed, that freedom of religion needs the others in order to really be that and not just mere freedom of worship. That those four freedoms are indivisible. Secondly, I was struck by your analysis of why these freedoms are now under threat in particular. What is it about this moment in time that you highlighted the rising intimidation by minorities with megaphones, the weaponisation of complaints processes, and the crumbling exemptions in anti-discrimination law because of the inherent weaknesses of the freedoms which are defined in a vacuum of legal regulation. And thirdly, I was struck by your analysis of the rising intolerance towards faith, struck both by the perceptiveness of the analysis, but also by the frightening rise of this intolerance. Patrick, tonight you have provided us with a clear and compelling analysis of the threats to our fundamental freedoms, and you've left us hanging because you haven't told us what the answers are. So I suspect, like everyone else, is very much looking forward to tomorrow night when you tell us how do we move forward in an era which perhaps is beyond Christendom. So on behalf of the trustees of the New College Lectures, on behalf of the Board of New College, on behalf of all of us here tonight, whether physically or online, Patrick, I'd like to express our deep appreciation and thanks. Please join with me in thanking our special guest tonight.
At this point, we'll thank our lecturer again and let him go and relax after a very interesting evening. Thank you, Patrick.
Thank you.
So just to conclude here, as we finish up, look again, thank you for joining us tonight. Refreshments will be served shortly, and I promise the coffee will be better tonight than it was last night. I'll just remind people about some of the services that we have here. The college publishes its own quarterly journal, which is available down the back. And there are also a number of other excellent books available, probably associated with previous New College lectures. New College and New College Postgraduate Village offer the lectures for free, but you're of course very welcome to contribute to the costs, towards the costs of holding these lectures. And look, we would love to welcome you back tomorrow night as we continue our journey and consider the idea of after Christendom. Please feel welcome to remain, but I would ask you that you do maintain social distancing, preferably if you'd remain seated while you're conversing with others. I can see the coffee approaching. Thank you for being with us here tonight, and please continue to enjoy the evening. Thank you very much.